Welcome to the third and the last part of the Indian Digital Personal Data Protection Act, or DPDP Act. The course has been broken into 3 parts. In this part, we will start with the roles and responsibilities of Data Protection Board, and then we'll move to special provisions of DPDP Act. We will then cover grievance redressal under DPDP Act and the various penalty provisions of DPDP Act. The Data Protection Board of India, or DPB, is a crucial part of India's data protection framework. Established under the DPDP Act, its primary role is to ensure compliance with data protection regulations and safeguard personal data privacy. Think of it as the enforcement arm of the DPDP Act. So, how does the DPB operate? The central government will appoint a chairperson and members with expertise in law, technology, or public administration. This diverse team will be responsible for overseeing the board's functions and making decisions on various matters related to personal data breaches and compliance issues. One of the key powers of the DPB is its ability to investigate data breaches. If an organization fails to protect personal data adequately, the DPB can step in to assess the situation. They have the authority to impose significant penalties, up to 250 Indian rupees crore for serious violations. This ensures that organizations take their responsibilities seriously. Additionally, the DPB serves as a point of contact for individuals, known as data principals, who have concerns about how their data is being handled. If you believe your rights have been violated, you can bring your complaints to the DPB for resolution. The Data Protection Board of India, or DPBI, is a critical body established under the Indian Digital Personal Data Protection (DPDP) Act. Its primary role is to enforce the provisions of the Act and ensure effective resolution of grievances related to data privacy. The board's composition is designed to balance expertise and accountability. At the helm is the chairperson, appointed by the central government. This individual is selected based on their expertise in areas such as data protection, law, IT, or public administration. Supporting the chairperson are members of the board who bring specialized knowledge in diverse fields like data management, cybersecurity, law, and governance. This multidisciplinary approach ensures that the board can effectively address the complex challenges associated with data protection. The Data Protection Board, or DPB, serves as a crucial regulatory body established to ensure compliance with data protection laws in India. One of its primary roles is to monitor how organizations handle personal data, ensuring that they adhere to the obligations set out in the DPDP Act. This oversight helps protect individual privacy rights and fosters accountability among data fiduciaries. When individuals believe their data rights have been violated, they can file complaints with the DPB. The board is tasked with investigating these complaints thoroughly. If a breach is confirmed, the DPB has the authority to impose significant penalties, up to 250 Indian rupees crores, on organizations found non-compliant. This enforcement mechanism incentivizes businesses to prioritize data protection. Additionally, the DPB plays an essential role in promoting awareness about data protection rights among the general public. By educating individuals about their rights and how their data is processed, the board empowers citizens to take control of their personal information. In this section, we will delve into how penalties are determined and enforced for non-compliance with data protection regulations. The Data Protection Board is empowered to impose penalties on organizations that fail to comply with the provisions set forth in the DPDP Act. This enforcement mechanism is crucial for ensuring accountability and protecting individuals' rights regarding their personal data. One of the primary forms of punishment is monetary fines. These fines can be significant, depending on the severity of the violation. However, it's not just about financial repercussions. Non-compliance can also lead to reputational damage. Organizations risk losing customer trust and facing public backlash, which can have long-term consequences on their brand. When a complaint is received or a violation is identified, the Data Protection Board will conduct an investigation. This process involves assessing all relevant facts and circumstances surrounding the alleged breach. After this thorough assessment, the board will issue a decision regarding any penalties. Importantly, Organizations have the right to appeal against any penalties imposed by the board. They can take their case to the appellate tribunal, which offers an opportunity for further review and potential reconsideration of the penalty. Under the DPDP Act, every data principal, essentially anyone whose personal data is processed, has the right to an accessible grievance redressal mechanism. This means that if you feel your rights have been violated or if you're unable to exercise those rights effectively, you can take action. Initially, data principals must approach the data fiduciary directly to resolve their grievances. The fiduciary is required to have a clear process in place for handling complaints, including appointing a grievance officer whose contact details should be readily available. This officer will assist you in addressing your concerns. If you're not satisfied with the response from the data fiduciary, you can escalate your complaint to the Data Protection Board of India. The DPB is responsible for investigating these complaints and ensuring compliance with data protection laws. If they find a violation, they can impose penalties on the organization involved. It's important to note that individuals must exhaust all avenues with the data fiduciary before approaching the DPB. The DPDP Act provides a structured approach to resolving disputes that arise from data protection violations. When individuals, known as data principals, feel their rights have been infringed upon, they can initially approach the data fiduciary directly to seek resolution. If this does not yield satisfactory results, they can escalate their complaint to the Data Protection Board of India, DPB. One interesting aspect of dispute resolution under the DPDP Act is the encouragement of alternative dispute resolution, ADR mechanisms. The DPB has the authority to refer complaints for mediation if it deems appropriate. This allows for a more flexible and potentially quicker resolution process compared to traditional adjudication. Moreover, while the DPDP Act establishes a centralized authority through the DPB for addressing grievances, it does not preclude the option of arbitration. In fact, arbitration can be a viable route for resolving disputes related to data privacy, especially when involving terms in data processing agreements. The confidentiality inherent in arbitration aligns well with the need to protect sensitive personal data. However, it's essential to note that while arbitration offers benefits such as speed and privacy, it also comes with challenges, including high costs that may deter individuals from pursuing their rights effectively. The DPDP Act provides a structured approach to resolving disputes that arise from data protection violations. When individuals, known as data principals, feel their rights have been infringed upon, they can initially approach the data fiduciary directly to seek resolution. If this does not yield satisfactory results, they can escalate their complaint to the Data Protection Board of India, DPB. One interesting aspect of dispute resolution under the DPDP Act is the encouragement of alternative dispute resolution, ADR, mechanisms. The DPB has the authority to refer complaints for mediation if it deems appropriate. This allows for a more flexible and potentially quicker resolution process compared to traditional adjudication. Moreover, while the DPDP Act establishes a centralized authority through the DPB for addressing grievances, it does not preclude the option of arbitration. In fact, arbitration can be a viable route for resolving disputes related to data privacy, especially when involving terms in data processing agreements. The confidentiality inherent in arbitration aligns well with the need to protect sensitive personal data. However, it's essential to note that while arbitration offers benefits such as speed and privacy, it also comes with challenges, including high costs that may deter individuals from pursuing their rights effectively. Children are particularly vulnerable when it comes to data protection. Their understanding of privacy and data usage is often limited, making it essential for organizations to implement robust measures to safeguard their information. The DPDP Act sets forth specific guidelines for processing children's personal data. First, let's explore the technical measures organizations should implement. 1. Age verification systems. Organizations must have effective age verification systems in place to ensure that they are collecting data from children only with appropriate consent. For example, a gaming app might require users to input their age before allowing access. 2. Consent management platforms. These platforms help manage parental consent efficiently. They should allow parents to provide or withdraw consent easily, ensuring that children's data is processed lawfully. 3. Security controls. Implementing strong security controls is vital. This includes encryption and access controls to protect children's data from unauthorized access or breaches. 4. Monitoring mechanisms. Organizations should have monitoring systems in place to detect any unauthorized access or anomalies in data processing activities related to children's information. Next, we'll discuss operational measures that organizations must adopt. 1. Staff training programs. Employees should be trained on the importance of protecting children's data and the specific measures in place to do so. 2. Documentation procedures. Maintaining thorough documentation of all processes related to the collection and processing of children's data. 3. Regular compliance audits. Organizations should conduct regular audits to ensure adherence to the DPDP Act and assess the effectiveness of their data protection measures. 4. Incident response plans. Having a clear incident response plan is crucial for addressing any breaches involving children's data swiftly and effectively. Now, we'll explore how DPDP Act aims to protect children's personal data and ensure their rights are upheld. First, let's discuss the principle of prioritizing the child's well-being. The DPDP Act mandates that all processing of personal data must prioritize the best interests of children. This means that any data processing activities should not be harmful to a child's physical or mental well-being. For instance, organizations must avoid practices that could lead to negative psychological effects or exploitative behaviors. Additionally, children should be protected from profiling and monitoring that could invade their privacy or influence their behavior in harmful ways. Safeguards against behavioral advertising are also essential to prevent targeting children with inappropriate content. Next, we move on to parental consent requirements. The DPDP Act stipulates that verifiable parental consent is mandatory before processing a child's personal data. This consent must be explicit and informed, ensuring that parents or guardians fully understand what they are agreeing to. In this context, parents act as consent managers for their children's data. Importantly, parents have the right to withdraw consent at any time, allowing them to maintain control over their child's personal information. Now, let's look at prohibited activities concerning children's data processing. 1. Data processing restrictions. Organizations are prohibited from tracking or engaging in behavioral monitoring of children. Targeted advertising directed at minors is also forbidden, as is profiling that could harm a child's well-being. Additionally, automated decision-making processes affecting children are not allowed. 2. Data processing that may cause harm. The Act explicitly prohibits any processing that could lead to physical harm or negatively affect a child's mental well-being and development. Activities that exploit children in any way are strictly forbidden. Now, we will discuss critical areas that organizations must focus on to ensure they are compliant when processing personal data, especially concerning children. First, let's talk about age verification. Organizations must implement reliable age verification mechanisms to ensure that they are not processing data from children without proper consent. This involves documenting the verification methodology used and regularly updating these systems to keep pace with any changes in technology or regulations. Maintaining verification records is essential for accountability and compliance. Next, we move on to consent management. Obtaining verifiable parental consent is mandatory before processing a child's personal data. This consent must be explicit and informed, meaning parents should fully understand what they are agreeing to. Organizations should maintain detailed consent records and have a clear process for parents or guardians to withdraw consent at any time. Now, let's discuss security measures. Organizations must adopt enhanced data protection standards to safeguard personal data against unauthorized access or breaches. This includes conducting regular security assessments to identify vulnerabilities and implementing breach notification procedures to inform affected individuals promptly in case of a data breach. Access controls and monitoring mechanisms are also crucial to ensure that only authorized personnel can access sensitive information. Consider a scenario where an educational app collects personal information from children. If the app fails to implement reliable age verification or does not obtain parental consent, it could face significant legal repercussions under the DPDP Act. Furthermore, if there is a data breach and the organization has not established robust security measures or breach notification procedures, it could lead to loss of trust from users and potential fines from regulatory authorities. In our increasingly globalized world, many organizations handle personal data across borders. The DPDP Act recognizes this reality and sets specific guidelines for transferring personal data to countries outside India. This is particularly important when the data is processed by a data fiduciary that operates within India or is involved in activities related to offering goods or services to individuals within India. Under the DPDP Act, any transfer of personal data outside India is subject to certain restrictions. The Act stipulates that data fiduciaries must meet requirements specified by the central government before making personal data available to any foreign state or entity under its control. For example, consider a tech company in India that offers software services globally. If it processes user data in a server located outside India, it must adhere to the DPDP guidelines. This includes ensuring that the foreign jurisdiction has adequate data protection measures in place or that appropriate safeguards are implemented to protect the data being transferred. The rationale behind these restrictions is clear. Protecting personal data is paramount, and transferring it without adequate safeguards could expose individuals to risks such as unauthorized access or misuse of their information. Let's discuss the data principles' right to grievance redressal under the DPDP Act. Under Section 13 of the DPDP Act, every data principal has the right to have readily available means of grievance redressal provided by a data fiduciary or consent manager. This provision ensures that individuals can seek recourse for any act or omission by these entities regarding their obligations related to personal data or the exercise of their rights. It is imperative that organizations establish clear and accessible grievance mechanisms. This means that data principals should easily find information on how to lodge a complaint or express concerns regarding their personal data. For instance, a user should be able to navigate a website or app and quickly locate the grievance redressal section, which outlines the steps they need to take. Once a grievance is received, the data fiduciary or consent manager is required to respond within a prescribed timeframe. Organizations should have internal processes in place to track grievances and ensure timely responses. Before escalating matters to the regulatory authority, data principals are required to exhaust all opportunities for redress under this section. This means that individuals must first engage with the data fiduciary or consent manager to resolve their issues before seeking intervention from the Data Protection Board. The board is established under the DPDP Act to oversee compliance with data protection laws and address grievances that cannot be resolved directly with data fiduciaries. Data principals should first exhaust all available grievance redressal mechanisms provided by the data fiduciary or consent manager. This means that before escalating a complaint to the board, individuals must formally raise their concerns with the organization and allow them an opportunity to respond. If the grievance remains unresolved after following the internal processes, data principals can approach the board. To do this, they must submit a formal complaint that outlines 1. Details of the grievance, a clear description of what transpired, including any relevant communications with the data fiduciary. 2. Supporting evidence, any documentation or evidence that supports their claim, such as emails or screenshots. 3. Desired outcome, what resolution or action they are seeking from the board. It's important for data principals to act promptly. The DPDP Act requires that grievances be submitted within a specific timeframe after exhausting internal remedies. Once a complaint is submitted, the board will review it and may request additional information from both the data principal and the data fiduciary. The board is required to respond within a reasonable timeframe, ensuring that complaints are handled efficiently. Now, we will discuss how individuals can seek recourse if they are aggrieved by decisions made by the board, as well as the mechanisms available for resolving disputes. Under Section 29 of the DPDP Act, any person who feels wronged by an order or direction issued by the board has the right to appeal to the appellate tribunal. This provision ensures that individuals have a channel to challenge decisions that they believe are unjust or incorrect. To file an appeal, individuals must do so within 60 days from the date they receive the order they wish to contest. The appeal must be submitted in a prescribed format and accompanied by a fee set by the regulations. Upon receiving an appeal, the appellate tribunal will give both parties an opportunity to present their case. After considering all arguments, it can confirm, modify, or set aside the original order from the board. The tribunal is committed to resolving appeals as quickly as possible, ideally within 6 months of submission. Once an order is made by the appellate tribunal, it is executable as a decree of a civil court. In addition to appeals, the DPDP Act encourages alternate dispute resolution methods. If the board believes that a complaint could be resolved through mediation, it may direct involved parties to attempt resolution through mutual agreement or appoint a mediator. Let's begin by understanding what constitutes a personal data breach. A breach occurs when there is unauthorized access, loss, or disclosure of personal data, which can have serious implications for individuals and organizations alike. Preventing such breaches is not only essential for compliance, but also crucial for maintaining customer trust. Under the DPDP Act, organizations face significant consequences if they fail to protect personal data. The Act outlines monetary penalties that can be substantial, depending on the severity of the breach. For instance, if an organization neglects to secure sensitive customer information, it may incur hefty fines that could impact its financial standing. Moreover, the reputational damage from a data breach can be devastating. Companies that experience breaches often face public backlash, leading to loss of customer confidence. Take, for example, a well-known company that faced severe criticism after a significant data leak. Their stock prices dropped, and they lost loyal customers. When determining penalties, regulatory authorities consider several criteria. They assess the nature and gravity of the breach, whether it was due to negligence or intentional misconduct, and the organization's previous compliance history. First, let's define breach notification. This refers to an organization's obligation to inform relevant stakeholders, specifically the board of directors and affected individuals, when a data breach occurs that compromises personal data. Under the DPDP Act, it's crucial that organizations notify these parties without undue delay. The legal requirements are clear. Failure to notify can lead to significant consequences, including hefty monetary penalties and reputational damage. Imagine a scenario where a company experiences a data breach but delays notification. This not only breaches legal obligations, but also erodes trust with customers who expect transparency regarding their personal information. The DPDP Act emphasizes that organizations must obtain verifiable consent from a parent or guardian before processing any data related to children. The legal requirements are clear. Failing to comply with these obligations can lead to significant consequences, including hefty fines and reputational damage. Imagine a scenario where a popular online service collects data from minors without proper consent. This not only breaches the law, but also erodes trust with users and their families. To ensure compliance, organizations must implement measures that guarantee age-appropriate data processing practices. This includes having robust systems in place to verify parental consent and maintaining thorough documentation of these processes. Best practices for processing children's data involve establishing clear policies that outline how this sensitive information will be collected, used, and protected. Transparency is key. Parents or guardians should be informed about what data is being collected and how it will be used. Under the DPDP Act, significant data fiduciaries are defined as organizations that process substantial amounts of personal data or sensitive personal data. These entities have enhanced responsibilities due to the potential impact their data processing activities can have on individuals' privacy rights. For instance, a major social media platform or a financial institution would fall under this category. Significant data fiduciaries must comply with specific obligations outlined in the DPDP Act. These include implementing robust data protection measures, conducting regular data protection impact assessments, DPIAs, and ensuring transparency in their data processing activities. For example, if a significant data fiduciary fails to conduct a DPIA before launching a new service that processes user data, it could lead to serious privacy risks. When these obligations are not fulfilled, the repercussions can be severe. The DPDP Act empowers regulatory authorities to investigate complaints and impose penalties on organizations that violate its provisions. For instance, if a significant data fiduciary is found to have mishandled personal data or failed to secure consent from users, it may face hefty fines and other enforcement actions. Consider a scenario where a healthcare provider, classified as a significant data fiduciary, neglects to implement adequate security measures for patient records. If a data breach occurs due to this negligence, not only does it compromise sensitive health information, but it also exposes the organization to legal liabilities and reputational damage. Let's talk about the penalties for non-fulfillment of duties by data principals under the Indian Digital Personal Data Protection Act. Now, under this act, data principals have a few key duties. These include providing accurate information to data fiduciaries, updating personal data when necessary, and ensuring that consent is informed and specific. If a data principal fails to fulfill these duties, there could be consequences, especially if their actions lead to data misuse or harm. For example, if a data principal provides incorrect or misleading information, which then leads to errors in processing by a data fiduciary, that could result in fines. The DPDP Act specifies that if the non-fulfillment of these duties causes significant harm, the data principal may be required to bear part of the financial responsibility for any penalties that are imposed on the data fiduciary. Moreover, if a data principal intentionally provides false consent or refuses to cooperate in a data correction process, they could face legal consequences, including fines and restrictions. The DPDP Act requires data fiduciaries to operate within the regulatory framework set by the Data Protection Board of India. The board plays a crucial role in overseeing the enforcement of data protection measures and ensuring that the rights of data principals are upheld. When a data fiduciary commits to a voluntary undertaking, they are making a promise to adhere to specific practices or take particular actions to ensure compliance with the Act. These voluntary undertakings are typically made in situations where the data fiduciary acknowledges the need for additional measures to secure personal data, address potential breaches, or rectify compliance issues. These undertakings might include, for example, adopting stronger security protocols or conducting additional audits. However, if the data fiduciary fails to fulfill this voluntary undertaking, it can lead to serious consequences. A breach of this commitment undermines the regulatory framework and could put personal data at risk. The board has the authority to impose penalties on data fiduciaries who fail to honor their voluntary undertakings. Now, let's address miscellaneous noncompliance with the provisions of the Indian Digital Personal Data Protection Act, or DPDP Act. While the DPDP Act provides clear guidelines for data fiduciaries and data principals, it also encompasses a broad range of provisions to ensure personal data is protected at every stage, from collection to processing, storage, and eventual deletion. Noncompliance can take many forms, whether intentional or unintentional. Some examples of miscellaneous noncompliance include failure to inform data principals about the collection of their data, not providing them with the right to access or correct their data, or not complying with the rules surrounding data retention. For instance, if a company fails to implement adequate security measures to protect the data they collect, or if they delay responding to a data subject access request, this could constitute noncompliance. Another example is failing to appoint a data protection officer when one is required under the law or neglecting to conduct periodic data audits.